Hello aspirants, welcome to AQ by AS YouTube channel. This video is another episode of our daily current affairs series. In today's video, we'll talk about preventive detention. So we'll focus on a recent landmark judgment by the Supreme Court. Recently the Supreme Court said that preventive detention can only be passed if a person is likely to disrupt the public disorder. So in this context, Supreme Court issued two directions, one to government, another to courts. So the Supreme Court said to government that preventive detention should be the last resort. So if there is an issue related to law and order, then existing legislation should be utilized to tackle with that problem. So they cannot use this preventive detention all the time. After that, Supreme Court issued directions to courts as well. Supreme Court said that while deciding the legality regarding preventive detention, they should be asking one question. And that question is, was the law sufficient to deal with a particular issue? So if the law is enough to tackle with the situation related to law and order, in that case, if you are using preventive detention as a tool, then it is absolutely illegal. Now let me give you an example. If two drunkards are fighting on road, then it is a law and order problem. You cannot call it public disorder. So the legislation, law should be used in order to deal with this issue. You cannot detain them by saying that it was a public disorder. So it is a law and order issue. So in our constitution, we have some safeguards against preventive detention. From the exams perspective, you must have little idea about these safeguards. So we have Article 22, which grants protection against preventive detention. Now, detention is of two types. One is preventive detention, another punitive detention. Punitive detention is when a person has been detained after trial or conviction. And preventive detention is when a person has been detained without any trial. Now, Article 22, remember this, very, very important. Now, under preventive detention, we have some rights. And the most important right, which is very, very important and can be asked in the prelims, and that right is that detention cannot exceed the period of 3 months unless an advisory board asks for an extension of detention. So this is something which you must be remembering. Moreover, another important point is that this right against preventive detention, it is available for both citizens as well as aliens. So this is another important point. Now in this context, I would like to mention about 44th Amendment Act 1978. This amendment reduced the period of 3 months to 2 months. And this reduction, although it has not been brought into force yet, and this 3 month period continues to remain in existence. So this is another important point that you must know. So from the exams perspective, remember the directions by the Supreme Court, directions to government, directions to court. Remember about Article 22, which grants protection against detentions. Remember about punitive detention, preventive detention, and do not forget about this 3 months period. Although there was this amendment which reduced the period, but it hasn't been brought into force yet. And I'm providing the content. You can download these notes and you can revise for the upcoming prelims. And if you have liked our video, then you can subscribe our YouTube channel for more such videos. And you can follow our social media platforms for daily current affairs content. So that's all for today's video. I'll see you in the next video. Thank you very much. Keep learning.